The gavel fell. It was a dull, heavy thud. A sound I had orchestrated perhaps 500,000 times in my life. The sound of finality, of judgment. Only this time, it wasn't my gavel. It wasn't my courtroom. And the judgment wasn't mine to render. It was a judgment on me. Having reviewed the petition of Thomas Vance and the accompanying report from Dr. Martin Alpert, the probate judge mumbled, staring at a spot on his desk, this court finds that the respondent, Eleanor Vance, is, by reason of advanced age and cognitive decline, incapacitated. Incapacitated. The word hung in the stale, fluorescent-lit air of the county probate court. It was a weak word, a cowardly word. The petition for a full conservatorship is granted, he continued, faster now, eager to get it over with. Thomas Vance is appointed conservator of the person and the estate. I sat perfectly still in the respondent S chair. My hands, which had signed orders that dismantled criminal enterprises and redistributed billions in fraudulent assets, were folded neatly in my lap. I looked at my son. Thomas, my only child, stood next to his lawyer. He didn't look triumphant. He looked relieved. He looked like a man who had just successfully pulled a ripcord on a faulty parachute. He adjusted the knot on his $300 silk tie, a tie I had bought him for Christmas, and refused to meet my gaze. I was, for 4 decades, Judge Eleanor Vance, United States District Judge for the Southern District of New York, appointed by Reagan, confirmed by a Senate that still knew how to compromise, and elevated to senior status when I realized I still had the mind for the work but not the patience for the administrative bureaucracy. I was the judge who presided over the Mancuso racketeering trial. For 18 months I stared down the 5 most dangerous men in the tri-state area. I received the threats. I lived with the U.S. Marshals. I sent all 5 of them to ADX Florence. I didn't to blink. I was the judge who handled the Penn Star Securities litigation, a multi-district case with 3.2 terabytes of discovery. The young associates were drowning, and I was the one who, in a status conference, pointed out the linchpin document they had all missed. I saved the pension funds of 40,000 people. I sacrificed. I missed Thomas's 8th grade graduation because I was in the middle of jury instructions for a high-profile civil rights case. I missed his 30th birthday because I was sequestered with the Second Circuit, hammering out an opinion on federal preemption. I had given my life to the law, to the system, and now that same system was being weaponized by my son to steal it all. The betrayal hadn't started with this hearing. This was just the sentencing. The crime had been plotted for months. It began subtly. "Mom, you seem tired." "Mom, are you sure you should be living in this big house alone?" "Mom, you paid the same utility bill twice. Let me help you set up autopay." Thomas, who had built a mediocre career in wealth management, which mostly meant taking a 2% cut from his friends' trust funds, had suddenly become deeply interested in my own. His wife, Sarah, a woman with a chillingly bright smile and an appetite for things she had not earned, was the architect. I could see her hand in it. The cognitive decline was a fiction they authored. The evidence was a house of cards. My fall. I had tripped over a loose paving stone on my own patio. My paranoia, I had, as I had done for 40 years, insisted on a security sweep of my chambers after a contentious ruling. Thomas and Sarah framed it as delusion. "She still thinks she's in danger, Doctor. She thinks people are listening." The paid specialist, Dr. Alpert, had visited my home under the guise of a friendly checkup arranged by Thomas. He asked me who the president was. He asked me to draw a clock. He was a professional witness, a man who charged $1,000 an hour to medically validate family coups. His report, which I was only given a copy of minutes before the hearing, was a masterpiece of clinical assassination. The patient exhibits significant executive dysfunction. I had argued with his flawed assessment of Marbury versus Madison. She displays paranoid ideation. I had asked to see his medical license. She is a danger to herself and her own financial well-being. I had told him and Thomas to get the hell out of my house. Now in the sterile probate courtroom, a place that smelled of old paper and ammonia, it was done. My lawyer, a public defender named Mr. Childs, who looked like he was 12 and who had been assigned to me that morning, patted my arm. "I'm sorry, Judge, we can appeal, but the standard of review is high." "The standard is abuse of discretion, Mr. Childs," I said, my voice flat, "and this judge just abused it." Thomas and Sarah approached, their faces arranged in masks of deep false concern. "Mom," Thomas said, his voice thick with the performance of it, "this is for the best. We're going to take care of everything." "Take care of what, Thomas?" I asked. My voice didn't tremble. It was the same voice I used to ask a lawyer why he'd missed a filing deadline. "Everything," Sarah chirped, sliding her arm through his. "Don't you worry about the bills. Don't you worry about the house. We're going to hire a wonderful woman to come and help you, to stay with you, a keeper, a jailer." They drove me home. My home. A 4-story brownstone in the village that I had bought in 1984 with the money from my partnership bonus just before I took the bench. A home Thomas and Sarah had long coveted. They used my key. "The court order," Thomas said, holding up the paper as if I couldn't read it, "gives me authority over the estate." "That means all accounts. I'll need your checkbooks, Mom, and any credit cards." I walked past him into my library, my sanctuary. The walls were lined with 2 centuries of jurisprudence, a first edition Blackstone, my own bound opinions from the Federal Reporter. He followed me. "Mom, don't make this difficult." "Make what difficult, Thomas? The theft?" He flinched. "It is not theft, it is protection. You were vulnerable. Dr. Alpert said so." "Dr. Alpert," I said, turning to face him, "is a purchased opinion. You filed an ex parte motion, you misrepresented my condition, and you shopped for a judge who is notoriously lazy. You didn't protect me, Thomas. You forum shopped your way into my bank accounts." His face hardened. The mask of concern fell away, replaced by the petulant anger I remembered from his adolescence. "You see? This is what I am talking about," he snapped. "This arrogance. You think you know better than everyone, better than the doctors, better than the judge." "In this case," I said, "I do." "It doesn't matter," he said, snatching the leather checkbook holder from my desk. "It is done. I am in charge now." He went into my office, the one where I'd drafted the opinions that shaped Second Circuit law, and started rummaging through my desk. "What are you looking for, Thomas?" "The safe combination, the keys to the deposit box, the brokerage account logins, the deed." He was a burglar with a court order. "You will not find them," I said. "I will," he grunted, pulling drawers. "Sarah, check the kitchen, check her bedroom. We need all the financial statements." He was looking for the paper trail. My $4.2 million in the Vanguard Municipal Bond Fund. My federal judicial pension, fully vested, paying 228 for us to choose a higher paying plan. Euro year. The brownstone itself, valued at over $8 million, free and clear. My net worth was approximately $12.5 million, and I was, according to the state of New York, too stupid to manage it. The helper arrived the next day. Her name was Brenda. She was large, silent, and moved with a heavy, deliberate tread. She wasn't a nurse, she was a guard. Sarah gave her the instructions. "Your job is to make sure Mrs. Vance is safe. She is not to leave the house alone. She is not to make any phone calls without our permission, and she is certainly not to use the computer. Her doctor said the blue light agitation is very severe." My lifeline was cut. For a week, I was a prisoner in my own home. I sat in my library, Brenda watching me from the doorway, and I allowed myself to feel the full, crushing weight of the humiliation. They had stripped me of my rights, my property, my name. I was no longer Judge Vance. I was the respondent. When I was Mom, I was incapacitated. Thomas, in his arrogance, had made a critical error. He had studied my finances, he had studied my health, he had forgotten to study my career. He assumed that because I was old, I was finished. He mistook dignity for frailty. He mistook silence for surrender. He forgot who I was. He forgot that for 40 years my entire life was about one thing, procedure, and that in a game of procedure, the most patient, most meticulous, and most ruthless player always wins. He had filed his motion. Now, I would file mine. The first rule of litigation is to know your battlefield. My home was no longer a sanctuary. It was a holding cell. Brenda was the warden and Thomas was the state, visiting only to gloat and pillage. "Just signing some papers for the accountants, Mom," he'd say, shuffling documents in my office. I could hear the whir of my personal scanner. He was digitizing my life, looking for hidden assets. The second rule is to identify your allies. I had none. My old colleagues on the bench, my friends in the U.S. Attorney's office, they were all beyond my reach. Brenda had dutifully disconnected the landline, citing robocalls, and my cell phone and laptop were, at the shop, being cleaned of viruses. I was incommunicado, but Thomas had overlooked one thing. He saw a frail old woman. He didn't see the habits of a federal judge. I don't use the cloud. I don't trust the cloud. For 40 years, I operated on a secure, closed-network federal system, and for my personal life, I maintained a similar analog discipline. He was looking for digital passwords. He should have been looking for the key to my fireproof filing cabinet, but he was, at his core, a lazy man. He assumed it just held old tax returns. He was wrong. My isolation lasted 8 days. On the 9th day, Brenda made a mistake. She was heating my soup, a bland, watery lentil, and the smoke detector went off. A piercing, irritating shriek. She waved a dish towel at it, annoyed. "It is very sensitive," I said from the library doorway. "You have to enter the reset code. It is *223#. She punched it in. The alarm stopped. She shot me a suspicious look. "How did you—" "I've lived here for 40 years, dear," and I said, returning to my chair. "It wasn't the alarm code. It was the unlock code for the old obsolete Nokia 3310 I kept in a hollowed-out copy of Holmes Pollock letters. A burner phone, before they were called burner phones. I'd kept it since the Mancuso trial, just in case. The battery was dead, but the SIM card was valid. The problem was the charger. It was in my desk drawer, the one Brenda locked. I needed a new plan. I waited 2 more days. I observed Brenda. Her weakness wasn't kindness, it was boredom. She spent hours on her phone, scrolling through social media with her thumb, her face illuminated by the vapid glow. "Brenda," I said, my voice intentionally frail. I wonder if I could ask a favor." She looked up, annoyed. "What?" "My son. He mentioned he was worried about my computer, the agitation. But I was thinking, maybe a different kind of screen. I used to love those nature shows, the ones with the birds. Do you think, could we watch one on your pad?" She was suspicious. "The pad?" "Yes, that tablet you have." A flicker of pity crossed her face. I was just a confused old lady. "It is an iPad, Judge, and I don't have Netflix on it." "Oh no," I said. "I wouldn't want to trouble you. I saw a commercial for the YouTube. They said it has everything." She sighed. "Fine." She brought over the iPad and handed it to me. "I'll find the YouTube for you." "Oh, thank you, dear. You were very kind." She opened the app and handed it to me. "Just type birds in that bar at the top." I took the tablet. My hands trembled, but not with age. "Thank you. This is very nice." She went back to her chair and her phone, confident I was occupied. I typed, "Not birds." I opened the Gmail app. It was logged into her account, of course. I hit add another account. I entered the credentials for an old dormant email address I'd created years ago under a pseudonym, themis44@gmail.com. The password was the case number of my first major reversal. I composed a new email. My fingers, stiff with arthritis, flew across the glass. To be Collins, retouchemail. Subject, Mancuso appeal, urgent. Ben, Article 3, Section 1. I am under duress. Code 18. Probate action 2025-0884. Thomas, Dr. Alpert. He has the house. He does not have the Chambers file. Bring the key. Bring Ms. Hayes. E.V. Ben Collins had been my judicial assistant for 32 years. He was a man of precise routine, fierce loyalty, and a deep, abiding respect for the institution of the federal judiciary. Article 3, Section 1 was our code. It establishes the judiciary and guarantees judges their office during good behavior. It was our shorthand for a threat to the bench. Ms. Hayes was not a person. It was my old briefcase, the one with the false bottom. I hit send. Then I cleared the app, deleted the draft, signed out, and went back to the YouTube homepage. I typed "Birds of Prey." And I waited. The Mancuso appeal in the subject line would, I knew, send a jolt of panic through him. It was our highest level alert. 2 days later, the doorbell rang. Brenda, annoyed at the interruption, lumbered to the door. I heard a man's voice, polite but firm. "Tay Benjamin Collins to see Judge Vance. I'm her former JA. I'm here to deliver her annual judicial pension paperwork." Brenda hesitated. "She's not seeing visitors." "It requires her signature," Ben said, his voice unyielding. "It's federal procedure, unless Mr. Thomas Vance has also been appointed her federal trustee." I checked the register. He has not. The invocation of federal procedure was a masterstroke. It was a language of authority that Brenda, a low-level functionary, instinctively respected. She opened the door. Ben Collins walked into my library. He was 65, impeccably dressed in his old-fashioned suit, and he carried a battered black leather briefcase. "Ms. Hayes." His eyes met mine. They were filled with a cold, professional fury. "Brenda, this is Mr. Collins," I said. "He and I have confidential matters to discuss regarding my pension. Please give us the room." "I'm not supposed to." Ben looked at her. He didn't raise his voice. "Young woman, I have been cleared by the U.S. Marshals Service for 32 years. You are interfering with the administration of a federal judicial matter. Do you want me to call the marshals?" She turned pale. "I'll be in the kitchen," she mumbled and fled. Ben didn't sit. He walked to the center of the room and looked around, sniffing the air, as if he smelled a gas leak. "Judge," he said, his voice low, "are you all right?" "I am incapacitated," I said. "Bullshit," he whispered. I pulled the probate docket. "Ex parte, a paid-for doctor. It is as fraud, Judge. It is as elder abuse." "Yes," I said. "Thomas has seized all accounts. He is liquidating. He has a helper watching me." "I saw," Ben said, his lip curling. "The helper is on her phone. Ben, he is looking for everything. But he is an idiot. He's looking on the computer. He's looking for account numbers. He isn't looking for the real resources." "The Chambers file," Ben said, nodding. "Precisely." Ben set the briefcase on my desk and clicked the latches. He opened it. Ms. Hayes was empty, save for a few manila folders. He turned the briefcase toward me and pressed a small, hidden catch near the hinge. The false bottom released with a soft click. Inside, nestled on dark velvet, were not documents, not gold. It was a set of old brass skeleton keys. "He thinks the assets are in the bank," and I said, "The assets are the bank." Thomas knew I had an estate. He did not know the nature of that estate. Years ago, during the Penstar litigation, I had become deeply concerned about asset protection, not just for me, but for the system. I saw how easily shell corporations and offshore accounts could make billions disappear. I used that knowledge. I didn't create a simple will or a living trust. That, yes, for amateurs. With the help of the most creative and discreet trusts and estates lawyer in New York, I had created a multi-jurisdictional asset protection structure. It was a fortress. The Chambers file, I explained to Ben, isn't one file, it's a key. Thomas has been scanning documents looking for the Vance family trust. He find it. The house isn't in my name. It's owned by a Delaware LLC. My brokerage accounts? They are held by a domestic asset protection trust in Nevada. My judicial pension is by federal law untouchable by creditors, or in this case, a conservator. "So what does he conserve?" Ben asked. "My checking account," I said with a thin smile. "He has full control of my $14,200 a Chase checking account, and he is spending it fast, on his lawyers, on Brenda. He is paying for the rope to hang himself." "But Judge Ben said, if the assets aren't in your name, how do you control them?" "That is the beauty of it," I said. "I don't not directly. I took one of the brass keys. These are for a safe deposit box, not at Chase, not at any commercial bank. It is at a private non-bank vault, The kind of place that doesn't ask questions if you have the key and the password. And inside? Inside, I said, is the Chambers file. A is a set of sealed, notarized and certified documents. They are the operating agreements for the LLC. They are the trust indentures, and they contain a contingency plan. A contingency plan? Ben's eyes lit up. He loved procedure. A poison pill, Ben. A clause I wrote myself based on the Penstar defense. It has a springing rights provision. I leaned forward. The trust document states that upon a hostile action, which is explicitly defined as an attempt by any descendant to gain involuntary control of my person or assets, two things happen. First, I continued, Thomas Vance is immediately and irrevocably disinherited. His status as a beneficiary is voided, ab initio, from the beginning. My God, Judge, Ben whispered. And second, I said, control of the trust springs to the co-trustee, who is then instructed to liquidate all assets and donate them, in their entirety, to the New York University School of Law, my alma mater. Ben was silent for a moment. He looked proud. He is not just stealing, Judge. He is disinheriting himself with every document he signs. Exactly. But we have a problem. The trust must be notified of the hostile action. The co-trustee must be activated. And I am trapped in here. The co-trustee, Ben said. Who is it? My old mentor, Judge Harrison. He died in 2018. Ben's face fell. So the trust is... The trust document also has a successor clause, I said. The co-trustee position defaults to a role, not a person. To the sitting Chief Judge of the U.S. District Court for the Southern District of New York. Ben sat down. Judge Roberts. Judge Roberts, I confirmed. A woman I have known for 30 years. A woman who hates probate court and despises greedy children. So, we just need to get the file and get it to her, Ben said, his mind racing. We do, I said, but I am incapacitated. I have no standing. I am not allowed to use a phone, and you are just my old assistant. We need a lawyer, Ben said. No, I said. We need a weapon. We need someone who isn't just a lawyer. We need someone who owes me. I thought back. 40 years on the bench. 40 years of lawyers. The ones who impressed, the ones who failed, and the ones who owed. Ben, I said, do you remember a young AUSA from the Mancuso trial? Hot-headed, brilliant, but sloppy with his warrants. You mean O'Malley, Patrick O'Malley. I saved his case, I said. I found a way to cure his defective warrant. He got his convictions. He is a defense attorney now, a shark. He runs his own shop. He is a bulldog, Ben agreed. I need you to get to that private vault. The key is in Ms. Hayes. The vault is at Manhattan Private Depository. The password is Themis. Get the file. Take it to Patrick O'Malley. Tell him Judge Vance needs a writ of habeas corpus. Habeas and judge, that S for people who are being unlawfully detained. Which I am. It is a federal action. It will bypass the state probate court entirely. It is bold. It is shocking. And it will get Judge Roberts' attention. It might be brilliant, Ben said. One more thing, Ben. My son, in his arrogance, has started noises. Noises. This house is old. It creaks. But lately, the creaks have been specific. The security alarm, the old one, the one the marshals put in, it has been malfunctioning. Lights flicker. The intercom gives off static. Thomas and Sarah are spooked. They think the house is haunted. Ben smiled, a slow, cold smile. The marshals still maintain that system, Judge. The old security protocols are still active. They just need to be woken up. I have a friend at the Marshal-S office. I'll let him know you concerned about the wiring. Good, I said. Thomas thinks I am losing my mind. It is time he started to question his own. Ben packed Ms. Hayes. He stood, all business. Brenda, I called. She shuffled in from the kitchen, her eyes suspicious. Mr. Collins is leaving, and I said, Thank you for bringing the paperwork, Ben. It was very informative. Always a pleasure, Judge, he said. He nodded curtly to Brenda. Ma, He walked out the front door. The lock clicked shut. I was alone again, a prisoner. But I was no longer a victim, I was a plaintiff. And the case of Vance versus Vance was about to get interesting. For the next week, the house changed. The hauntings, as Ben had arranged, became more pronounced. It was a beautiful, logical application of psychological warfare. The old U.S. Marshal S security system, designed in the 90s to protect me from the mob, was a brute force piece of analog engineering. It wasn't smart. It was just loud. One night, the panic alarm in the kitchen went off at 3:15 a.m. Not the main siren, just a deafening, localized beep, beep, beep. Brenda stumbled out of her room, her hair in a net. "What is that?" "Oh dear," I said, standing in my doorway. "That is the old pantry alarm. It goes off if the pressure changes. A mouse, perhaps." Sarah and Thomas, who had moved into the guest suite to keep a closer eye on things, ran downstairs. "Turn it off!" Sarah shrieked, holding her ears. "I don't know how!" Thomas yelled. He punched the keypad, which only made it louder. It stopped abruptly on its own. The house was silent, except for Sarah East's heavy breathing. "This place is a death trap," she whispered. "It's just old wiring, dear," I said sweetly. But it was more than alarms. The lights in the library, where Thomas was spending his evenings scanning my personal letters, began to flicker. Not randomly. They would dim, precisely, every time he opened a new file box. Logical explanation. The old system had pressure sensors in the floor tied to the light circuits. A marshal, sitting in a van 2 blocks away, was having fun. "This is not normal, Thomas," I heard Sarah argue. "Eric's her. He's doing it, or this house is, I want to sell it now." "We cannot sell it until the estate is settled," Thomas hissed back. "Now shut up. You'll wake her." I was already awake. I was listening. The hauntings served a dual purpose. They frayed the nerves of my antagonists, making them sloppy, and they provided a perfect cover for Ben. While the alarm was blaring, Ben, using the service entrance key ID given him, slipped into the house. He wasn't just my JA. He was my courier. He brought me a burner phone, courtesy of Patrick O'Malley. And he brought me evidence. "He is moving fast, Judge," Ben whispered, meeting me in the kitchen while Brenda was, I assumed, tied up in the bathroom, thanks to the mild, flavorless laxative I'd been adding to her morning coffee. "He's been on the phone with a man named Victor." Ben slid a small, thumb-sized audio recorder across the table. "He's not just paying bills, he is investing." "My money," I stated. "Your $14,200, Ben corrected. "And it is almost gone. He is desperate. He is trying to liquidate the brokerage accounts. He is furious that they locked." "The Nevada Trust is doing its job," I said. "What else on the recorder?" "O'Malley East PI put a bug in Thomas's car. This is from yesterday." I pressed play. Thomas, voice. "Look, Victor, the money is coming. It is just tied up. My mother, she has these crazy complicated accounts." Victor, voice, heavy accent. "Complicated is not my problem, Tommy. My problem is $80,000. You told me this was a sure thing. Your mother's dementia was supposed to make you rich." Thomas. "It is. Just give me 2 more weeks. The court is on my side. I just need to get the judge to sign the order to liquidate." I clicked it off. A gambling debt. "Or worse," Ben said. "O'Malley is running Victor's name. But Thomas is getting desperate." He filed a new motion. He handed me a document. My hands were steady as I read it. "Motion to compel sale of real property." He is trying to sell the house, I said. The cold rage was a familiar, focusing sensation. "The hearing is in 3 days, Ben said. He is claiming the upkeep is a drain on the estate's limited resources, and that you require a more modern, single-level care facility. Jake is trying to make me homeless. He is trying to get liquid," Ben countered. "The $8 million from the sale would solve all his problems." "He has forgotten one thing," I said, tapping the document. "The house isn't in my name. The estate doesn't own it. The Delaware LLC does." "He'll find that out at the hearing," Ben said. "No," I said. "That is not good enough. I don't want to block him. I want to trap him. If he testifies under oath that the house is mine, knowing he is trying to sell it, he is committing perjury. But Judge, O'Malley, the habeas petition? It is too slow, I said. A federal writ takes time. It has to go to a magistrate. This probate hearing is in 3 days. We have to move in the state system. We have to use their motion against them. This was the complication. The brilliant federal strategy was a sledgehammer, but I needed a scalpel. Ben, I said, my mind working, I need you to call O'Malley. Tell him the habeas petition is Plan B, Plan A is the hearing. What are you going to do? I said, am going to attend. They won, to let you, Ben said. Brenda, Thomas. Brenda, I said, is about to have a very bad day. The plan was simple. Patrick O'Malley, as my newly retained counsel, would appear at the hearing. He would present my signed affidavit, which Ben would sneak in and out, and at the last moment inform the court of the LLC S existence, blowing up Thomas S. motion. It was a good plan. It was not, however, my plan. It was O'Malley S., and it was weak. It was defensive. I preferred to attack. The day of the hearing, Brenda woke up to find the house secured. The haunting had become a lockdown. The old Marshall S system, at my remote request via Ben, had fully engaged. The heavy-duty magnetic locks on the doors and windows were active. Brenda, holding her keys, found she could not open the front door, or the back door, or the service door. She was trapped. With me. Her phone, conveniently, was also not working. The system included a low-level signal jammer. She was pounding on the reinforced glass of the front door when Thomas S. car pulled up. He was there to pick her up, to drive her to the hearing, where she was scheduled to testify about my rapid decline. He got out, saw her, and ran to the door. He jangled his own keys. Nothing. "What is this?" he yelled through the glass. "It is locked," she shrieked, panicked. "It won't open. Use the code." "It is not working." I watched from the library. "The code is *223#. I called out. Thomas punched it in. The system, of course, did not recognize it. "Mom!" he roared, his face purple. "What did you do?" "I am incapacitated, Thomas," I said, walking to the door. "How could I do anything?" "Brenda, get her! We're late!" Brenda ran at me, her professional calm completely gone. She grabbed my arm. "You be coming with us?" "I don't think so." From the street, 2 things happened at once. A black sedan pulled up behind Thomas S. car, and a uniformed NYPD officer turned the corner. Ben, I presumed, had made an anonymous call about a hostage situation. Patrick O'Malley got out of the sedan. He was exactly as I remembered, red hair, rumpled suit, and the predatory grin of a wolf who just smelled blood. "Thomas Vance," O'Malley boomed. Thomas spun around. "Who are you?" "Patrick O'Malley. I am Judge Vance, S. Attorney. Officer." He waved to the cop. "Good, you won't re-hear. My client is being held against her will by this man, and this woman who appears to be assaulting her." Brenda dropped my arm like it was on fire. "This is a misunderstanding," Thomas sputtered. "She's my mother. She's incompetent. I have a court order." "You have a conservatorship order," O'Malley countered, walking right up to the door. "You do not have a detention order, and you certainly don't have the right to lock her in her own home, which, by the way, you are illegally attempting to sell." He turned to the cop. "This is a civil matter, officer, but I am having my client S. Federal Security Detail unlock the premises. We'll be at the courthouse if Mr. Vance would like to proceed with his motion." "Oh." Malley looked back at the glass. He winked at me. Then he pressed a small remote. With a hiss and a loud clack, the magnetic locks disengaged. Thomas and Brenda stumbled back, shocked. The front door swung open. I walked out, adjusted the collar of my coat, and got into the back of O'Malley S. sedan. "Where to, Judge?" he asked, sliding into the driver ES seat. "Probate court," I said, "and drive fast. I don't want to be late for my own execution." We walked into the probate court. It was the same room, the same smell, but I was different. I was no longer the ambushed respondent. I was the counter-plaintiff. Thomas and Sarah were already there at the petitioner S table. Their lawyer, a slick man named Harris, was shuffling papers. When Thomas saw me walk in, flanked by O'Malley, his face went from purple to grey. "What is she doing here?" he hissed to Harris. She cannot be here." "All rise," the bailiff called. The judge, the same one who had mumbled his way through my incapacitation, walked in. He looked annoyed. "This is in re Vance," he said. "We were here on petitioner S motion to compel the sale of 124 West 10th Street. Mr. Harris?" "Thank you, Your Honor," Harris said, rising. "It's a simple matter. The estate, yes, liquid assets are nearly depleted. The upkeep on the brownstone is $15,000 a month." A lie. It was $4,000. "We have a buyer," Harris continued. "A cash offer, $7.5 million. We simply need the Court S approval to sell the asset so we can move Mrs. Vance to a facility more suited to her needs." "And where is the respondent?" the judge asked, not looking up. "I am right here, Your Honor." My voice cut through the room. It was not loud, but it was projected. It was the voice that had stopped 100 lawyers mid-sentence. The judge S. head snapped up. He stared at me. I was sitting in the gallery, O'Malley beside me. "Mrs. Vance," the judge said, flustered, I was not aware you would be attending. She is not Mrs. Vance." "Your Honor," O'Malley said, standing up, "she is Judge Eleanor Vance, and she is not the respondent, she is the victim. Patrick O'Malley, Your Honor, I refiled my notice of appearance this morning. We are here to strenuously object to this motion." "Objection?" Harris sneered. "On what grounds?" "The conservator has a fiduciary duty to manage the estate. The house is a liability." "My client would like to be heard," O'Malley said. "She's incapacitated," Harris snapped. "She's present," O'Malley countered, "and she has a right to be heard. Or is this court in the business of silencing the elderly as well as bankrupting them?" The judge flushed. The New York Law Journal leak Ben had arranged was clearly on his mind. "I will allow it," the judge said. "Briefly, Judge Vance." I stood. I did not approach the bench. I stood where I was. "Your Honor," I began, my voice clear and steady, "Mr. Vance in his motion claims two things. One, that I am in need of funds. Two, that he has the authority to sell my home." I looked at Thomas. "He is wrong on both counts." "Your Honor," Harris interrupted, "this is irregular. She is not counsel, but I am a material witness," I said, "to my own financial status." "Then you will be sworn," the judge said, eager to regain control. I was sworn. "Judge Vance," O'Malley said, taking the lead, "let us talk about this house. Mr. Harris and Mr. Vance claim it Salcura House, is it?" "No," I said. The room went silent. Thomas, who had been whispering to Harris, stopped. "What?" Harris said. "No," I repeated. "The property at 124 West 10th Street is, and has been since 1998, the sole asset of a Delaware-based corporation, Themis LLC." O'Malley handed a document to the bailiff. "Certificate of Incorporation for Themis LLC, Your Honor." "This is... Harris stammered. "This is a trick, a shell game." "It has called estate planning, Mr. Harris," I said. "Something your client should have asked me about. As I am not the owner of the property, the estate of Eleanor Vance cannot sell it. The motion is therefore moot." The judge looked at the certificate. He looked at Harris. He was angry. "Mr. Harris, did you not perform a simple title search?" "My client assured me," Harris said, glaring at Thomas. I thought it was," Thomas burst out. She's lying." "Mr. Vance," I said, "you're an officer of the court in this matter. You are a fiduciary. Are you sure you want to continue this line of perjury?" "Your Honor," Harris shouted. "It gets better, Your Honor," O'Malley said, holding up another document. "Because not only does Mr. Vance not have the right to sell the house, he doesn't have the need to." "The estate is broke," Thomas yelled. "The checking account is broke, Thomas," I said. "The one you'd have been looting to pay your consultant, Victor, and to pay Brenda, who I've discovered, has a prior conviction for petty theft." Brenda, sitting in the back row, went white. "My incapacitated client," O'Malley said, still has full access to her federally protected judicial pension, which Mr. Vance has no authority to touch. She also has other resources. This motion was not filed out of need. It was filed out of greed. It is a fraudulent conveyance, and it is an act of criminal conspiracy. This is an outrage, Harris said. No, I said, this is a fact. Thomas looked like a trapped animal. His eyes darted from me to his lawyer to Sarah. Sarah, I noted, had gone very, very still. Your Honor, Thomas said, his voice pleading, she is confusing everyone. This is that Mancuso file, the one she is obsessed with. She is paranoid. She has all these secret files. Hidden companies. It is proof she is incompetent. He was desperate. He was flailing. And he had just very stupidly handed me the weapon I needed. He had mentioned the file. The Mancuso file, O'Malley said, feigning confusion. No, I said, a cold realization dawning. I think he is referring to a different file, a file he has been trying to find. I locked eyes with Thomas. He thought he was calling my bluff. Your Honor, I said to the judge, I believe my son is referring to my actual estate planning documents, the ones he couldn't find. Where are they? The judge asked, intrigued. They are sealed, Your Honor, I said, at my request, for my protection. Sealed? Thomas leaned forward, his eyes gleaming. See? She's hiding assets from the court. Your Honor, I demand you order her to unseal those documents. Harris was trying to pull Thomas back to his seat. Tom Donald, unseal them, Thomas shouted. Let us see what she is hiding. Let us see what she found. It was the ultimate irony, the title of my story, delivered by the villain himself. He thought the sealed documents were his salvation, a pot of gold. He had no idea they were his sentence. Your Honor, O'Malley said, a slow, dangerous smile spreading across his face. My client concurs. We will consent to unsealing the documents. In fact, we insist on it. The judge was, for the first time, in a procedural box he couldn't mumble his way out of. Both parties had agreed. Very well, he said. This hearing on the motion to sell is suspended. We will reconvene in 24 hours. Mr. O'Malley, you will produce these mahably sealed documents high to the court, and only to the court. We will, Your Honor, O'Malley said. And Judge Vance, the judge added, a new grudging respect in his tone, you will be present. I would not miss it, I said. The next day. The courtroom was different. It was full. Ben and O'Malley had, I gathered, spent the previous evening making phone calls. The Law Journal leak had become a flood. The gallery was filled with lawyers, reporters, and to my deep surprise, 2 of my old colleagues from the Southern District. Judge Roberts, the chief judge, sat in the 3rd row, dressed in a civilian suit, watching. Her presence in a state probate court was the judicial equivalent of a nuclear bomb. The probate judge, when he saw her, almost dropped his water glass. Thomas and Sarah were at their table. Thomas looked giddy, high on adrenaline. He thought he had won. He thought he was about to find the treasure. He thought the title of this chapter was his. Mr. O'Malley, the judge began, his voice shaky, you were to produce the documents. We were, Your Honor. And we have, O'Malley said. Ben Collins, dressed in his finest suit, walked up the aisle. He was not carrying a file. He was carrying a single, thick, cream-colored envelope, sealed with the dark blue wax of the U.S. District Court. He handed it not to the bailiff, but directly to the judge. The judge looked at the seal. He looked at Judge Roberts in the audience. He broke the seal. He pulled out a multi-page document. As he read, his face went from pink to white to a deep mottled red. He read for what felt like an eternity. The only sound in the room was the heavy, clumsy breathing of my son. I see, the judge finally whispered. Your Honor, Harris said, we request that the documents be shared with the petitioner, as he is the conservator of the estate. That, the judge said, his voice booming, will not be necessary. He looked at Thomas. Not as a judge looks at a petitioner, but as a man looks at something he has just scraped off his shoe. Mr. Vance, the judge said, his voice ice. Your son, my client, asked for these to be unsealed, Harris interrupted. Shut up, Mr. Harris, Judge Roberts called out, clear as a bell from the gallery. Harris shut up. Mr. Vance, the judge continued, your mother, Judge Vance, did not just create a simple trust. It seems that 15 years ago she created a contingency plan. A legal masterpiece, I must say. Thomas was still smiling. A plan to protect her? Good. To protect her assets, Mr. Vance, the judge clarified, from you. The smile froze. This document, the judge said, holding it up, is a springing trust indenture, and it outlines with shocking and I must say prophetic detail a specific event of hostile action. It defines this event, the judge read, as any attempt, direct or indirect, by the beneficiary, Thomas Vance, to declare the grantor, Eleanor Vance, incapacitated or to seek conservatorship or guardianship over her person or estate by any court in any jurisdiction. Sarah, beside Thomas, made a small gasping sound. Upon the triggering of this event, the judge continued, the document, which was certified by Judge Vance S., physician and psychiatrist at the time, as her being of sound mind, dictates 2 immediate consequences. Thomas was no longer breathing. First, Thomas Vance, and any of his issue or assigns, is to be immediately and irrevocably disinherited. He is to be treated for all purposes of this trust and any subsequent will as if he had predeceased the grantor. No, Thomas whispered. No. She wouldn't She did, the judge snapped. And second, the judge paused, looking at the document in disbelief. Second, the entirety of the Trust ES assets, the $4.2 million brokerage account, the Themis LLC, which holds the property, all personal effects, are to be immediately transferred to the co-trustee, who is then instructed to liquidate and donate the full amount, without delay, to the Judge Eleanor Vance Scholarship Fund at the New York University School of Law. Thomas made a sound. A low, keening animal sound. And who, the judge said, is the co-trustee with sole authority? Why, that would be the sitting Chief Judge of the Southern District of New York. He looked terrified at Judge Roberts. Judge Roberts stood up. Your Honor, she said, addressing the probate judge, as co-trustee I have reviewed the event of hostile action. I find that Mr. Vance S. petition, Exhibit A, and the purchase testimony of Dr. Alpert, Exhibit B, have triggered the clause. She held up her own file, which Ben must have delivered to her last night. As of 9 a.m. this morning, Judge Roberts announced, I have executed my duty. The assets of the Vance Trust are now in the process of being transferred to NYU. The motion to sell the house is not just moot, it is an impossibility. The house has already been donated. No, Thomas screamed. He stood up, knocking his chair over. No, you can it's mine. Shah's incompetent. I'm the conservator. You, I said, standing for the last time, are disinherited. He stared at me, the full weight of his actions, his arrogance, his greed crashing down on him. He hadn't found a hidden treasure in the sealed documents. He had found his own sentence, the sentencing. This, the probate judge stammered, this entire proceeding was fraudulent. It was, O'Malley agreed, and now we have the matter of damages. Your Honor, O'Malley continued, we are withdrawing our request for a habeas petition in the federal court. We believe the state court is, finally, equipped to handle this. The conservatorship is dissolved, the judge declared, slamming his gavel, effective immediately. We were not done, O'Malley said. He handed a new file to the bailiff. And we are filing a criminal referral with the District Attorney A.S. Office for elder fraud, conspiracy, and perjury. We are also filing a civil suit against Mr. Thomas Vance, Mrs. Sarah Vance, Mr. Harris, and Dr. Martin Alpert, jointly and severally, for conversion, intentional infliction of emotional distress, and legal malpractice. We are seeking the return of all funds, $14,200, taken from my client S. personal account, plus punitive damages. Sarah, at the mention of her name, began to cry, not tears of remorse, tears of a co-conspirator who just realized she was going to be deposed. And finally, O'Malley said, we request an immediate permanent restraining order, barring Thomas and Sarah Vance from coming within 1,000 feet of Judge Vance, her home or her chambers. The judge didn't even hesitate. Granted. Thomas was catatonic, his expensive suit rumpled, his face grey. He was a man who had just stolen $14,000 and lost $12.5 million to do it. The judge looked at me. Judge Vance, I apologize. The system, I said, is only as good as the people who serve it, and the checks and balances designed to protect it. I looked at Thomas, his eyes were empty. He had subverted the system, and the system, in turn, had done exactly what I had designed it to do. It had protected itself. I walked out of the courtroom. Judge Roberts and Ben fell into step beside me. That emo Judge Roberts said was the most brutal summary judgment I have ever witnessed, and it was beautiful. Thank you for your cooperation, Chief, I said. Eleanor, she said, squeezing my arm, you would have done the same for me. We walked out into the bright, cold sunlight of a New York afternoon. Justice. It's a strange thing. For 40 years I administered it for strangers. I balanced the scales, I weighed the evidence, I pronounced the sentence. I had always believed the law was a shield, meant to protect the innocent. But in my own home, in my own life, I had been forced to forge it into a sword. A weapon of last resort, hidden in plain sight, sealed not just by wax, but by the arrogance of an antagonist who could not imagine the woman he called Mom was, in fact, still the judge. Thomas and Sarah lost the house, of course. They lost the money. They lost their reputation. Last I heard, they were facing criminal charges, and Victor was not a patient creditor. I still live in my house. Themis LLC, under the new management of NYU, has granted me a lifetime tenancy, a life estate, they called it, a professional courtesy. The alarms are quiet. Brenda is long gone. Sometimes I sit in my library, surrounded by the wisdom of the law, and I think about that probate court. I think about the look on my son S. face. Is there any justice in a mother disinheriting her child? Is there any victory in a parent outmaneuvering their own blood? I don't know the answer to those questions. But I do know this. He thought I was a frail old woman, a victim to be managed. He forgot that I am and always will be a servant of the law. He brought a petition, I brought a precedent, and in the end the court, my court, ruled.